But first, let's take this backgrounder by Aisha Ubali.
Last year, the central bank revealed plans to launch an initiative that will allow lenders recover loans from deposit accounts of loan defaulters from any bank or financial institution in the country. This initiative is being carried out in conjunction with Nigerian Interbank Settlement System (NIBBS) and the Bankers Committee. The process began in May 2019 when the Bankers Committee declared war on non-performing loans in the country. This gave rise to a new policy tagged Operational Guidelines on Global Standing Instruction, expected to take off from August 1st, 2020. The instruction gives banks the power to debit loans and accrued interest due from bank accounts of loan defaulters across the Nigerian banking system. The process will be managed by the NIBSS using customers' bank verification numbers. By this directive of the Central Bank of Nigeria, CBN, customers interested in accessing bank loans must allow lending banks have access to all other accounts belonging to them when they default on a loan. The aim of this new policy is to encourage lending by banks, reduce cases of non-performing loans, while also creating a watch list of chronic loan defaulters.
All right, thank you very much, Aisha Obali, for that backgrounder. Now, joining us to discuss this issue, would like to welcome Professor Uche Uwaleke. He's a professor of capital market and former commissioner for finance in Imo State. Prof, I'd like to have you with us in the studios.
My pleasure. Thank you very much.
Okay. And also joining us from our Kaduna Network Center is another of our regular guests on Good Morning Nigeria, Associate Professor of Business Entrepreneurship and Dean, School of Postgraduate Studies at Kaduna State University, Yusha Ango. Associate Prof, delight to have you again on Good Morning Nigeria.
Good morning. It's my pleasure to be here.
And with us via Zoom from Lagos is the President, Chartered Institute of Bankers of Nigeria, Bayo Olubemi. Bayo, good morning and welcome to the program. Where that the audio will improve in the course of the program. Now, still in Lagos and also via Zoom is Professor Joseph Abugu. He is of the Faculty of Law, University of Lagos. We also like to thank you for joining us on the program this morning.
And good morning, Nigeria.
All right, gentlemen, let's begin the conversation with Professor Uche Uwaleke with us here in the Abuja studios. Just before we get into the specific details and implications of the new policy on loan defaulters, can we have a sense or an idea of the extent of unpaid or loan default by borrowers in the Nigerian financial system?
Yeah, thanks. Kinsley, of course, you know the indicator that you can use to have a sense of that is the non-performing loans, the quantum of non-performing loans in the banking industry today. Over time, that has been on the high side, quite disturbing. The CBN has a threshold. The threshold for the CBN is 5%, that non-performing loans in the banking sector shouldn't be higher than 5%, of course, in the interest of financial system stability. Over time, it's been, a lot high. As a matter of fact, there were times it was as high as 15, 16%. But in recent times, it has been a noticeable decline in non-performing loans. If you listen to the central bank's MPC communique, the very last one, the central bank talked about non-performing loans declining to as low as 6.4%, compared to 10% or thereabout on the average, previously. So we have noticed some level of decline in non-performing loans. And if you take the history of bank distress in Nigeria, the fact of the matter remains that bad loans, have remained at the core. particularly loans from insiders, loans given to directors, and the rest, have contributed to bad loans. So what has happened in the past, it's like CBN over time has been introducing one measure or the other. Ordinarily, it is something that status report should have taken care of. If you go to borrow in a bank, for example, you are borrowing from bank A. Bank A is expected to do like a background check, do some inquiries, status report, on the borrower. But because the borrower knows that, in most cases, the borrower knows that the cases of serial defaulters now, that borrower knows that the bank has a right of set-off. By that, for example, you have a current account that has a credit balance, and there is also a loan account. The bank has a right to exercise an automatic right of set-off, particularly when the loan agreement is breached. So because the borrower understands that, he goes to another bank to also contract another loan. So it is because of that the central bank over time introduced what we call the credit risk management system, that is meant to centralize credit information of all borrowers. That's the credit bureau. And over time, of course, it has also helped to reduce the level of non-performing loans in the banking sector. But the problem is still there, which is why I welcome this idea of global standing instruction, because what it does is to reinforce the already existing systems that we have in place. I was saying ordinary banking practice ought to have obviated that, the status inquiry. But the status inquiry has limitations. Limitations in the sense that banks have a duty of confidentiality to their customers. So there's a limit to what a bank can disclose. In status reports, details are not usually disclosed. You find a bank, for example, saying something like, you may deal with, or we consider it, good for the numbers. Phrases like that without providing details. And because of the risks inherent in it, because the bank that is also providing the information can also be sued, not only by the borrower for libel, if he considers some of those information defamatory, or even the bank that is making the inquiry can sue. So it is these limitations that we'll find, particularly relying on the 1963 case of Helly Bryan and Hellas and Partners, which says once there's a disclaimer, once a bank puts a disclaimer, the bank is escapes liability. So banks tend to be careful when they are giving reports on borrowers. That's why this global standing instruction is very timely and is very important.
All right, thank you. Let's bring in Professor Yusho Ango. You just listened to Professor Uche Owaleke, but I'm more inclined to the historical aspect of what he said, because in the past we had bank distress in this country, which actually led to a number of issues that came up in the banking system, right? And it all started by bad loans. People who are in the banks borrow to their relations who don't pay back loans, and when that happens, it has a ripple effect, and that has affected so many banks at that time. Now we are back in a new system. And now the Central Bank of Nigeria is of course now saying, look, we have to go global in terms of dealing with bad loans. Now, in your opinion, how bad really is the situation in Nigeria at present, and how would you like the Central Bank of Nigeria to address it? Should we now depend on that global approach, or do we develop our own approach to it?
Well, good morning. The historical perspective, especially of bank failure, just like Prof said, is that in Nigeria, a lot of what has happened in terms of bank failure was because of bad debts. The banking system itself, if you look at the trajectory, started from about 1892 or 94, And it passed through phases, and those phases, originally, there was a phase in which there was no regulation at all. That was the laissez-faire kind of system from that 1890s up to 1950s, before the Central Bank Act was enacted and before the First Banking Act was enacted. And now that brought the regulatory, strictly regulatory regime, and that lasted up to about 1986 when the Structural Adjustment Program came into place. And after 1986, it became deregulated substantially until the consolidation. This is the trajectory. Now, all along the line, banks were failing. They were failing largely, initially, due to poor management, knowledge, of the practitioners, of the technicalities of banking, and also due to bad loans. This has happened so many times in Nigeria. Now, the central bank has come up with so many initiatives over time, trying to key in, first of all, to international standards, especially the Basel II Accord, and ensuring, bringing out a lot of prudential guidelines to ensure that banks comply, and especially in managing their credits, and ensuring that there's a very good and robust system of credit administration, a system that ensures that only those who are deserving get loans. That is what the central bank has been doing. So now, by bringing these global standing standards in, by saying that, now they discovered that people were running away, they will have debit or they will have loans that are lingering in some banks, and then go somewhere else and have monies. It's a very good initiative, certainly. But it's not the only initiative. There are quite a number of initiatives that have been brought in by the central bank over time, and they are trying to actually, like I said, key into global initiatives. Now, there are quite a lot of things that can be done to improve this system, but I believe this standing order that will be signed by customers of banks that will enable banks to actually debit them using NIPS and other media wherever they have credits and they have defaulted in paying their liabilities with these other banks is a very good initiative. That is my first take. Thank you.
All right. Thank you very much, Professor Yusha Ango. We'll return to you in the course of the conversation. Let's go over now to Lagos, where we are introduced Professor Joseph Abugu, who is with us via Zoom. Professor Joseph Abugu, of course, two of your areas of specialization in commercial law are corporate governance and law of banking and negotiable instruments. So just tell us, how and why are we now at this juncture of the application of the global standard instruction to deal with recalcitrant debtors?
Thank you, Kingsley, for the opportunity to be here this morning. The point has been made that bad debts in the financial institutions are a contributory factor to bank failures. This is evident over the years. A cursory reference to the amount of bad debts that have been taken over by AMCON, glaringly verifies the effect of bad debts on the financial system in general. Now, so how do we deal with loan defaulters? I think that is the key issue. And this latest attempt by the Central Bank of Nigeria to address the problem. Now, for me, I look at it from, as having two legs. The first one is how to make loan defaulters honor their obligations to their financial institutions. The second one is how to prevent loan defaulters from having access to further facilities from financial institutions. Now, the first leg seems to be the object of the new global standing instructions being introduced by the CBN. from the directive that has been issued by the CBN, this will allow financial institutions to be able to debit accounts of loan defaulters in other banks other than their banks, where the accounts are domiciled. Now, that raises a number of interesting legal issues. And I have no doubt that this will open a door to a fury of litigations, in the nearest future. Now, let's look at it from this perspective. Basically, the banker-customer relation is a contractual relationship. And so, the rules that governs the management of a banker's account, the customer's account with the bank, is based on contract. Now, it's based on contract. And basically, the law is very clear that a banker has no right to transfer any sum of money from one account to the other. Even the right of set-off, which my colleague, referred to earlier in this program, it has to be enshrined in a contract. So you find that when you open account, one of the forms they give you is that which gives the bank the right to set off. That's the base of that right. Otherwise, they own account, even when domiciled in the same bank. Now, so does this new CBN policy now directly alter contracts of the parties? I don't think so.
Well, you seem to have a little hitch there. And let's return to Abuja here, where we have a Professor Uche Uwaleke. You'll be itching to say something in connection with
yes,
some of
in
the
response to what Prof said. Yes, yes, of course, there is a contract between the customer, and the bank. I am sure too that has been, thought through, which is why the central bank is saying, one of the guidelines of the GSI is saying that the customer, the specific rules of the stakeholders are clearly, spelled out, whether that of the borrower, that of the creditor bank, participating financial institutions, the NIPS, and the central bank. These are the major stakeholders, and their roles are clearly spelled out. Now, with respect to...
You know what, Professor Uwaleke, we'll have to pause you. We understand the signal to Professor Abugo has been restored.
Okay.
So that he can conclude his thoughts along the lines that he was speaking earlier. Prof, can we get your contribution?
Yes. I said so with respect to existing loan defaulters, unless the banks are able to coerce them to come and sign some form of consent form, then this policy will not work with them. And I think the policy also, the directive anticipated this, because most of the provisions are designed with respect to new loans, such that when customers now want to access new loans, they are given instruments, warrants to sign, authorizing the banks to do this, interbank transfers. Now, so that only cures or addresses the problem as to the future and not to the present loan defaulters. Now, but even with respect to the future, we must note that this directive is not a statutory provision. It's not a law emanating from the National Assembly. And so it is also contestable whether the CBN and the Bankers Committee, that conceive of this idea, can, by way of a policy directive, interfere into the individual contracts between customers and the banks. So at the end of the day, one actually, in my view, I actually see an effort to over-regulate this sector by the Central Bank of Nigeria. In saner climes, these things could be done differently. The practice of rating agencies are not well defined in Nigeria yet, and their prominence and effectiveness, have been effectively tested in the financial sector. Here, we're going to run into problems. If I am signatory to a family account, you want to be able to reach that family account to satisfy a private debt. If I hold an account in trust for an organization, you want to be able to reach that account to satisfy a personal debt. If I belong to an association or a group where I am a co-signatory and my name appears because my BVN is linked to that account, you want to be able to reach that account to satisfy a private debt. These will certainly raise issues. We must also not forget that sometimes with respect to defaulting loans, it is because the customer has contest or claims with respect to this way his account has been managed. And so you see customers complaining of, excess charges on their accounts, interest rates being, escalated without their consent and so on and so forth. Now, this new regime will give banks the opportunity to be, to be defiant and not cooperative in addressing the claims of customers with the hindsight that, of course, they have a global standing instruction that enables them to reach out to sister banks to be able to effectively deal with this customer. These are going to raise serious issues that will be contested in the court, and I think so.
All right. Thank you indeed. I think we should be able to break this down, Professor Waleke, for many Nigerians to understand, the technicalities, involved in this. Loan defaulting, no doubt, has become a recurring decimal, not just in Nigeria, but elsewhere across the globe. And of course, when the Prof was talking about the contractual relationship between the banker and, of course, the customer, right? Now, is it possible for a borrower to borrow from a particular bank and perhaps before he could service the loan, he's also borrowing from another bank, perhaps to start another business or something? I don't know whether that's a dual opportunity given to a borrower, because what happens is that at the end of the day, it's covered that someone is owing many banks. One businessman is owing so many banks. So what is the reason for that? And if that is what is happening, how best can the central bank develop a policy, apart from the one that's we're talking about that is global, that can address that domestic financial system that we have?
Yes, thank you very much. As you rightly mentioned, Prof has, of course, enumerated the legal implications. There's no doubt that the bank, owes a duty of confidentiality to the customer, as part of that contract. But there are also conditions, conditions in which those conditions, that duty can be waived. One of which is if the court requires that the customer's account, be made public. The other is at the express consent or permission of the customer, of the borrower. So when a borrower has been given a mandate form and he duly executes it, I think he waives that that contract. And that's why I was talking about the roles of the stakeholders clearly, spelled out. The borrower, at the point of taking the loan, before the loan is disbursed, is expected to understand the terms and conditions of the GSI, mandate that is about to execute. The participating financial institutions are also expected to do same. The creditor bank is expected to explain to the borrower those terms, and is only after the borrower, has understood those terms that, of course, he executes. And once he executes that becomes binding on him. As I said earlier on, this is more like an expansion of the, banker's right of set-off. Of course, I know that there are conditions by which even that right can be, applied, including giving a notice, to that customer before you can set off his account. But that right of set-off is just within a particular bank. This one is now global, such that because over time we've noticed that there has been this culture, okay, of loan default among borrowers in Nigeria. So we have now a group of borrowers known as predatory debtors. Okay, they are serial loan defaulters. And how do we cure that? As I said, over time, the central bank, has come up with a number of measures, and somehow these borrowers find a way of beating these measures. That was what led to, Prof mentioned it, that what led to, AMCOM. Today, AMCOM is carrying over 5 trillion naira. 5 trillion naira, okay, of toxic assets, of bad debts, of banks. And how do we remedy that? Okay, it's global standing instruction. We go a long way in ensuring that non-performing loans go down. We go a long way in entrenching that culture of responsible behavior on the part of borrowers. We'll also go a long way in helping banks also carry out a good credit appraisal. And then, for me, you asked that question. What is important is even the prevention. Prevention. Ensuring that credit investigation is properly done. Credit appraisal is properly done before any loan is given out. And that's why I tell my students where I teach that even after you have checked the person's capital contribution, you have checked the person, you have checked the business condition, you have checked the person even has collateral, provided collateral, okay? You have checked the person's capacity. What is critical is the person's character. The 5 C's of credit investigation. Character.
I'm not putting the shop. Is
Yes.
that the reason why, in some cases, you find big borrowers that are people who are in big businesses having a running battle in court with some banks? We've had, protracted, lawsuits between one big borrower and
Yes.
the bank.
Yes.
And
these borrowers are taking advantage of the fact that our law courts take very time. Legal proceedings take time to resolve, which was why at the recent public hearing on Bofia, where I made a presentation, I advocated for the setting up of special courts for banking-related issues, as we have in Pakistan. Pakistan and India also has a debt recovery tribunal, where you have special courts to deal with these issues. And cases are resolved very fast. You find out that in those climes, non-performing loans, are quite low. So for me, it is prevention. And part of that prevention is also ensuring that the right people work in these departments. That also speaks to the competency framework which the central bank, has. So implementing that competency framework is very important.
All right, Professor Waleke, thank you very much. You just mentioned another special bank as a proposal. People just going to wonder how many special banks, how many special courts are we going to have? Special courts to try electoral offences, special courts to try loan defaulters, special courts to try rapists, special courts to try traffic offenders, special courts to try all kinds of things. But your point is noted with regard to the substance of our conversation this morning. Well, we're glad to have Mr. Bayo Olugbemi back with us via Zoom. He's President, Chartered Institute of Bankers of Nigeria. Mr. Olugbemi, of course, you've had the benefit of listening to the other 3 guests, and I believe you also have your own background information to this. But just tell us, against the background of what you have heard and what you wish to say, is the GSI, that's the Global Standing Instruction, potentially a game changer in the relationship between banks and, again, recalcitrant loan defaulters in Nigeria?
Very much. Good morning once again, Nigeria. And I want to appreciate all the speakers in the house. Thank you very much. I think when you have problems or challenges in any facet of life, you want to see how you can provide solutions to them. And I think in the banking industry, as regards loan defaulting and non-performing loans, I think CBN and the Bankers Committee have put together this GSI so that the issues of non-performing loan can be, if not totally resolved, can be brought down to the BRS minimum. And I've heard Prof. Abugu talk on the line of law, and I've heard other people, Professor Waleke and so on and so forth. I think CBN is very clear, and the circular that was passed or released in this circumstance is very, very clear on the policy and the responsibilities of each of the participating institutions, the PFIs, the loan borrowers, the NIBs, the CBN itself, and so on and so forth. And let me say this, Professor Abugu, this GSI is new, number one. Number two, it's not curing, it's not meant to cure the non-performing loans of the past. The only issue is that it was dated back to just September last year when the issue was first raised. If you remember, this circular was actually released in September last year, and the way that the loan letters going forward or credit letter going forward should be crafted was also released, which means the non-performing loans prior to September 2019 cannot be cured with the GSI. But from September 2019, when the first information was released and the banks were given the sample of how to craft or draft the loan conditions and conditionalities going forward, then it becomes effective. So the issue is to a large extent to resolve the perennial loan defaulting in the Nigerian banking system. And we have had over the years, I've been in banking for some years now, and you see at times it's laughable when you see those days some of the banks will release circulars to staff and say, Mr. ABCD is owing us so much naira. If you know his whereabouts, please let us know. And I laugh. I, as a junior staff or middle level staff somewhere, I never gave the loan. You know who and who gave the loan. Why are you now passing circular to me to go and be looking for the person? And at times, you even get the names of popular people, socialites, who will go to parties every weekend, painting the social circle very red. Meanwhile, you are passing circulars to me to go and look for them. Where they are. And I think one of the reasons then was that a lot of compromises here and there from within the system and from outside the system. And you see, when we are growing up in the banking industry, we have had cases where somebody will take loan to do a Greek or whatever, and the next thing is that he has gone to marry a second wife, or he has gone to build a house with the money, or go and buy a car with the money, which was not what it was meant to do. So I think GSI has come one to resolve the issue of character that Professor Waleke mentioned. Character is very, very important. You have what we call the 5 C's of credit. You may have all the collaterals of this world. You may have very good business idea. You may have good cash flow that will come in even when you have taken the loan to execute the business for which it was taken. But when you don't have character, when you don't have strength of character, you may refuse to pay the money back, especially when there has been compromises here and there. So I think that was what this GSI is meant to resolve. And I think we should give it a chance. I believe it will work. I believe it will bring sanity into the banking system. I believe it will bring some sort of character reformation, especially from the borrowers and from even compromised bankers themselves. So let's give it a chance. And let me also correct one impression I think Professor Abugu mentioned. I'm not sure the intendment was also to affect corporate bodies for now. If we look at the conditions and the participating institutions or persons, I think mainly it's talking mainly about personal accounts. Personal accounts, either they are joint or maybe as a father, I am operating an education fund or in trustee or in trust for my children. So I think those are the accounts that will be affected for now, not corporate. Because if I and you are in one social club or a business club and we are joint signatories, I think that is not affected from the CBN circular and the intendment. I think basically it will affect 1, personal accounts, either savings or current. 2, joint account probably between the wife and the husband. And 3, trust account that you have for your children. And from from what we have seen, the circular says that if, for example, you are defaulted to the tune of 100,000 naira, including the principal and the interest, and excluding penal charges, if you are owing 100 and you have been asked to pay and you refuse to pay, the GSI can be triggered by the PFI, the bank that is owing the creditor. And of course, if you have 20,000 naira in your account with the bank, it will be taken. Then they will go to the joint account of yourself and your wife. If you meet 50,000 naira there, it will be taken, making 70. The remaining 30, they will go to the account where you are trustees, to your children's account, your children's loan who are minors, or your children's maybe education account minors, and you are the sole signatory. They will go there, and if there is 60,000 naira there, they will take the balance of 30,000 naira. And of course, there are conditions that must be met, and there are penalties in case of default. I think I should rest there for now. Thank you very much.
All right, I'm not allowing you to rest because we've raised a number of issues that I would like you also to touch on. One is character. How does one determine character when you are into a transaction, banking transaction, when somebody needs a loan? What should be the measure to put in place to determine the character of the person you're dealing with? Again, is there any preventive mechanism that can be put in place by the bankers to determine whether this borrower is really eligible, irrespective of the fact that he may have collaterals, is eligible to take this loan? And of course, is there a way of looking at the business, the business background of this borrower to understand whether he could really apply this loan to that business? Is there because you talked about also about compromised bankers, because some of these things happen not just like that. There are persons who are deeply rooted in ensuring that loans are given or loans are not given in the banking sector. So let us know how the bankers could go about this, because of course many people are interested in taking loans, but not all of them are prepared to, of course, obey the instructions or the guidelines or the loan conditions before they take the loan.
Thank you very much. When I mention bankers themselves, I don't mean all bankers. We have, in every facet of life, you have people who have no strength of characters. And I can't deceive you by saying all bankers are 100% correct. But that is changing fast because from CIBN and from CBN, there has been a lot of emphasis on ethics and professionalism in the past few years, especially since the bank collapse of 2007, 8, 9. There has been a lot of measures taken to ensure that bankers themselves behave, apart from the misbehavior of creditors. And going back to your specific questions on how to determine character. In the banking industry today, thank God, we now have credit agencies, what we call the credit bureaus. 15 years ago, thereabout, they were not existent. And even when they came, it took time for us to be able to key into what they are doing. I'll give you an example. In recent time, even the microfinance banks now have keyed into the services of these credit rating agencies or credit bureaus, such that somebody who is just owing a microfinance bank and has defaulted. I have live cases. My church and some group of people have a microfinance bank, and they extend loans to people. And one person, unfortunately, he has finished paying his loan, but for one reason or the other, his name was in the credit bureau, and he went to approach a commercial bank. And sorry, go back to AYZ Microfinance Bank. You are owing them only ridiculous amount, 20,000 naira or thereabout. You pay loan in a commercial bank. So I think we have taken a step forward in the right direction, and we believe that with the credit bureaus strengthened, I think we have about 3 of them now, strengthened and their services is well known or more publicized and is being used, I think it will be a kind of check on people of bad characters to continue to come to the banking industry and take undue advantage. Professor Waleke mentioned the issue of people who are serial borrowers and serial defaulters. They go from Bank A to Bank B, and in fact, some will even go and borrow money from Bank B to settle part of Bank A's loan, go to Bank C, and it revolves. But with the credit bureau that's now working, and with this GSI also, I think it will be a way of checking the characters of who will be borrowers or who will be loan defaulters. And how do you measure that? Of course, you have to employ the services of credit bureaus, number one. Number two, you also have to ensure that you do what we call background checks in other claims, especially with one single means of identification. I think one of the major problems that we have today in Nigeria, not just in the banking industry, is the issue of identification, proper identification. And unfortunately, in Nigeria today, though I learned that the president set up a committee recently to harmonize all our different silos of identity management, the BVN, the National Identification Commission, the driver's license, the immigration services, international passport, the MTNs and the Airtel of this world. All of us in the capital market also, we all have different means of identification. I think this should be harmonized, and I thank God that I think in the past 1 week or so, the president has set up a committee to harmonize all these different silos of identification. So a major problem that we have in Nigeria today is identity management. Unlike, like I said, in other claims, with one single identity, there's nowhere you can run to. If you like, run to inside the ocean, they will find you out there. But unfortunately, in Nigeria, you can take money here and run somewhere else. So with proper identity management system, we'll be able to even follow up people who have shady characters, and we'll be able to nip it in the bud before they go and mess up the banking system.
Thank you very much, Mr. Olugbemi, for your comments. We'll return to you in the course of the conversation. Let's return to our Kaduna studios, where Associate Prof. Yushau Ango is still with us. Yushau, one of the points that Professor Joseph Abugu raised, it said, look, the one implementation challenge we are likely to have with this is that the odds would now most likely be in favor of the lending institution, namely that in the past, one of the commonest grounds for loan default had to do with the failure of the lending institution, that's to say a bank, in addressing the claims of the debtors, to say there are all kinds of arbitrary charges, administrative interest rate adjustment by the banks, and that when that lingers for so long a time, you find that the quantum, that's to say the principal and interest payable, balloons and then gets, of course, beyond the capacity of the borrower to pay back. Now with the GSI, which is the Global Standard Instruction, is it not possible, as Professor Abugu suggests, that banks may very well say, look, settle this, otherwise we'll use whatever money is available in your other accounts elsewhere to defray this?
Well, maybe first of all, let me say that I've had the privilege of working in the banking industry for close to two decades, and I worked substantially in the credit and credit analysis section. So I know for a fact that normally when you are assessing any credit, or especially when you are granting the credit, the first thing you do is to give an offer letter, a letter that stipulates the terms on which the credit is granted. Now, part of that letter will indicate all the charges and will give the bank, the privilege sometime of adjusting the rate. Normally, you charge a credit based on what is called the prime lending rate, plus or minus, depending on the circumstances. And banks are allowed, basically, to increase this or reduce this depending, of course, on market dynamics, largely the central bank MPR. Now, having said this, yes, it's true, also something that is stated clearly is sometimes the penalties that will be charged if a customer defaults in paying the certain credits. Now, interesting thing is that the GSI said that penal charges will not be part of what will be deducted. It's only the principal and interest that will be deducted. And I also like to stress the comment made by the chairman or president of the bankers committee that said that actually these guidelines is for individuals. Now, certainly that is something I also wanted to stress. It's only on individual borrowings, retail borrowings. If you look at the quantum, I don't have the figures now, but I'm sure the quantum of borrowings in the banking industry to the retail sector is small, even though of recent what I observed is that banks are more or less, pushing credits to individuals, so long as they know you are in some paid employment or something like that, they are pushing credits to you, probably because they don't want to lend to certain sectors, so they tend to lend to, they just felt it's safer to do that. Now, having said this, these guidelines will assist as far as the retail credits are concerned. Now, if we look at the history of defaults, in terms of credits, a large chunk of defaults happen, largely in the corporates. And I think, I don't know, this program alone will not permit us to actually dwell on the problems that comes from the banks themselves, in terms of not assessing, not understanding the industries in which they lend, and in granting or moving with the crowd sometimes. If you look at the total number or amount of, if you like, the amount of bad debts now, right now, you find that quite a number of them, almost close to half, are in the petroleum or petroleum-related sector. Why? During the boom, when a lot of these independent oil marketers were importing oil, they granted huge quantum of credits to them. Now, quite a number of them have issues, with the authorities in reconciling those ones, so they have not been able to pay. Quite a large chunk of our credits is actually in the corporate side, and much of the credit that go bad is also on the corporate side. Then also, maybe I should also mention Professor Oleke's initial comments, especially when he looks at the non-performing loans to total loans in the sector. He said it has improved. Actually, what happened is that it has been oscillating. And why it oscillated is, by 2007, for example, it was less than 5%. By 2010, it was more than 10%. But by 2013, it had come down to 3%. Why? Because the Asset Management Company of Nigeria had bought a lot of the toxic assets off the banks. But the last I saw was 2016. It had risen up to about 13%, which means a lot of these loans are growing, largely because these banks are not doing the right thing. They are not studying these industries very well. They are moving with the crowd. They are granting credits, to sectors that appear to be doing very well. They have not studied these industries very well. They are concentrating too much to certain sectors. And when there is a problem with that sector, the whole system collapses. But luckily, because we have these safety nets, in terms of AMCON and the likes, they absorb these loans, and it becomes public responsibility. Now, the liability is on the public. The 5-point-something trillion of toxic assets that are with AMCON are actually responsibilities of the public. Now, meanwhile, those who have granted these credits, who are at the top management, have done that. They will exit, they will have all their bonuses, they will have all their claims, but they have caused substantial problem. A large chunk of the bad debts we have in the industry is not from individuals, even though there are many in number, but in quantum, I'm sure is much more in the corporate. So I hope that the central bank will come up with something of the GSI that will affect corporates. And then that will also ensure, like we said, like the bio said, to ensure that the practitioners, those who are actually granting these credits, are also held to account for whatever they have done. Thank you.
All right, thank you indeed, and let's return to the studio here where we have Professor Owaleke. He has actually raised a number of issues, from what he submitted a short while ago, and that gives a sense of understanding the nitty-gritty of the problem. It's not just on the side of the borrower, but also on the side of the banking system itself, right? Because when you issue a loan, huge loan to a corporate body, it's not just individuals. And when you issue a loan to a corporate body, it's usually a huge loan. And when it comes to the issue, of course, of paying back, it becomes difficult. And when, of course, the people at the helm of affairs in those corporate bodies perhaps may have left office or having them replaced, it becomes more difficult and it compounds the entire problem. So what I want to ask you is this. In a situation where a corporate body borrows from a bank, and in the course of doing business, there's this defaulting, in terms of payment. How does the bank begin to, look for its money? What should be the first step of the bank, to begin to look for its money? Because what happened in the past, if you recall, early 90s, was that in trying to, get loans back, some persons were sought on the way, took their cars, some houses were taken away from them forcefully, and what have you. So what should play out in the actual sense of it now, if such situation repeats itself, notwithstanding the new policy we're talking about now, which has been issued by the Central Bank of Nigeria, which I'm not sure is holistic in terms of addressing all the issues relating to debt.
Yeah, thank you. The global standing instruction is with specific reference to individuals, as you said. Now, in terms of corporates, I think it speaks more to corporate governance, dealing with issues around corporate governance, because that is one thing that will help check the over-concentration of credit, that will help check over-exposure to a certain, specific sectors. The truth of the matter is that these guidelines are there, these rules are there, even from theory. Okay, we teach, for example, that if before you extend credit to a corporate person, that you must carry out some analysis. Okay, we have this acronym called PAT. Initially, I mentioned the 5 C's of credit. We have PAT. P stands for purpose of the loan. What's the purpose of the loan? Okay, is it for something that is genuine? What is the amount? The A there is amount. What is the amount? Somebody wants to do a project of maybe spanning 2-3 years, for example, and you are giving a loan, a facility for 1 year. That is a funding mismatch. Okay, the loan will even mature even before the projects begin to generate any form of revenue. The R is the repayment. Okay, the repayment terms and the source of the repayment. Okay, does the person even have the capacity? You're looking at the cash flow of such organization, whether the cash flow can sustain both interest and principal payment. You're looking at the terms, and then principally the S there part. The S there is security, collateral security. So when a corporate defaults, you have already taken collateral. So that is why the bank will resort to disposing of that collateral, because it's part of the agreement that you signed. So that is the whole idea behind a collateral. So there must be a collateral whose value must be higher than the amount of loan that you're taking, such that once it happens, the bank can dispose of that collateral and recover the money. So it boils down to preventive measures. Mr. Bayo is the national president of Chartered of Bankers of Nigeria. He is my president. I am also a member, and by the grace of God, I'm the chairman of the Chartered of Bankers of Nigeria, here in Abuja. Okay, we emphasize, competence in the banking sector. If you have the right people doing the credit analysis, we wouldn't have so many, loans going bad. And that is why the central bank came up with the competency framework. I'm sure the president will mention it. Competency framework. Somebody has read civil engineering, for example, and because he's looking for work, he has someone in the bank, you give him a place in the bank and put him, because the opening is in credit, you put him in credit. Maybe after just 2 weeks training. That shouldn't be so. Civil engineers are brilliant people. So if that civil engineer wants to remain in the banking sector, he should get a certification. He should go and qualify as get professional qualification to now function very well in that capacity. So that is what we are saying. Competency is very important. When we implement competency framework in the banking sector, for example, and we follow through the rules, as I said, these rules are all there. So it's just that sometimes they are observed in the breach. Okay, if they are followed, and the central bank, of course, particularly in recent times, has been on top of banking supervision, particularly with respect to the excess charges talked about. I'm aware that the Consumer Protection Department, has recovered, so much and refunded, a lot of people with respect to excess charges, which is why I'm happy that the global standing instruction, okay, when it is triggered, it doesn't cover these excess charges. It will not cover penalties. It's just principal, and interest. And one thing we should also understand is that the instruction is very clear that banks must use that as a last resort. It must be a last resort. There are penalties, sanctions for even wrong, trigger, 500,000 naira, and some other sanctions there. So it has to be used as a last resort, number one. Number two, the customer or the borrower must understand the terms and conditions. So it is the duty of the creditor bank to explain the terms and conditions to the. So it's only when you've understood it and you agreed and you execute that it becomes binding on you.
Well, Professor Waloke, thank you. You said the banking customer must understand. I think there's a presumption when they push the paper to those who want to borrow money, and there's the last line there to say a consent, to say I have read and understood the terms, and the man is desperate.
Yes, because you're desperate to get the loan.
And once he signs, that means he has executed, he's bound.
Yes.
And then when the basic comes, that's when the trouble also arises. All right, gentlemen, we're going to have to take a short break now. When we return, we'll continue with the conversation.
As a strong immune system increases the chances of victims surviving COVID-19, a corruption-free society creates opportunities for citizens to thrive and prosper. Build your immunity. Stop corruption now. Report all acts of corruption to ICPC on this toll-free number 0800 2255 4272. This message is brought to you by ICPC and NTA.
She cried. She cried in anguish and in pain. She bears the scourge of her grief. She toils in vain for justice and succumbs to silence. He gloats over his malady. Like a beast, he pounces with no remorse. Her cry meant nothing. Her pain feeds her shame. Like an orphan, she is left to grieve in solitude. But no more will she cry in vain. Her adversaries will henceforth bear the brunt of their bestiality. Rape is evil. Rape is a plague. A pandemic of monumental consequences. We must unite and kick it out of our society.
Connect with NTA and stand against rape and rapists.
This message is brought to you by the Nigerian Television Authority, NTA.
Nigerians, let us take responsibility. Stay healthy, stay safe, and curb the spread of the virus. Take responsibility. The coronavirus spreads from one person to another. Let us avoid crowd gathering of any kind for any reason. Take responsibility. Avoid traveling from one state to another during these lockdown restrictions. Obey all the rules that are put in place. Take responsibility. Stop spreading fake news and unverified reports about the coronavirus. There is no known cure for COVID-19. take responsibility. Observe all the measures that can help stop the spread of the virus. Together, we can do this, but only if we take responsibility. This message is brought to you by the Nigerian Television Authority, NTA, Africa's largest television network.
All right, you're welcome back, and it's still Good Morning Nigeria live on NTA's network service. Let's rejoin Professor Joseph Abugu via Zoom from Lagos. Professor Abugu, you may wish to respond to some of the issues that have come to light by the other panelists in terms of responding to either the propositions you made earlier or to some other points that they have raised. But assuming there's no such response, I just wanted to ask, we are here talking about, as it were, cash transactions. In other words, what could be attached under the global standing instruction will be cash at bank, as the accountants would say. What is likely to happen when there is conversion? Look, a borrower has taken money, and as we know fairly well in this environment, the borrower may wish to marry a wife, another wife, buy a new car, and more importantly also, more likely, say, look, convert it to a property, a fixed asset. Is this rule likely to apply once there's that conversion? How are you going to trace and track those converted assets and then get them? How will the global standing instruction apply to all of this?
Thank you so much. The first thing I want to say is that the legality or otherwise of the global standing instructions to be able to reach a third account that is jointly held either for your wife or a member of your family will still have to be interrogated, because that account you want to reach has its own mandate instructions. And if that account was created before the effective date of this GSI directive, and a mandate correlating the power you have now is not in that, the mandate for that account, then you have a problem. So in effect, the GSI, even though presently particularized to individuals, as has been made clear by the president of the CIBN, you still need parallel mandates, in my view, not only with the new account you want to open, but also with the account you want to reach. Otherwise, the banking institution that will be acceding to your request under the GSI will be flaunting the contract between the account holders and the bank. That is one. So, two, as also has been said, the bulk of the defaulting loans out there that are posing serious danger to the banking system are in the corporate sector. And experience has also shown that the problems with these accounts are usually with respect to documentation. With respect to documentation, some of these loans are disbursed without proper documentation and securitization. And so the banks then find it difficult when push comes to shove and there's default to be able to follow the securities that would otherwise have been in place, in addressing and recovering their monies. Now, as has been alluded, this is usually an in-house problem. So until the problem of proper documentation and securitization of loan transactions, are done, now credit departments will not be able to make informed judgments as to whether a particular credit ought to have been granted or not. Most of these huge loans are granted, at top level management, and disbursement will often take place instantaneously, even before documentations are put together. So that's a problem for the banking industry. The GSI is simply a shortcut I think it is an experiment, and that experiment is good, no doubt, to legal test. It may be extended to corporate borrowers, and that of the problem in the banking industry is.
Okay, let's bring in our guest, Bayo Hulubami. Bayo, you've just listened to Professor Abugu there saying that the GST is actually not holistic in the sense that it does not address the issue of corporate borrowing. I wish to be corrected about that. But the important thing now to know is whether this GST that we are trying to put, a policy that the central bank is trying to put in place, will it address all issues concerning loans and defaulting when it comes to paying back loans in Nigeria? If not, what are other measures that should be put in place? Because historically speaking, Nigeria has had its fair share of failed banks. Of course, we know that in the last maybe a decade or thereabouts, we've not experienced that. But of course, nobody will want that to return. And what really led to what happened was this kind of situation. So if GST is not going to address holistically all issues concerning loans and defaulting when it comes to paying back loans, what else should be done? Is there any kind of perhaps a domestic approach that we can imbue into it, perhaps for Nigeria alone, to understand, because of course Nigerians believe in borrowing, and these days banks practically force people to borrow. And as Kingsley rightly pointed out, sometimes you are given this document to sign without really allowing you to go through the document to know, the extent to which you are committed, or the level of your commitment. You just sign and get a loan. And in the long run, you discover that you have signed a document that you are not prepared, to actually, attend to its request, because of course all those documentations have their issues. They have raised items that you are going to be responsible for at the moment to sign it. But many people sign without knowing the level of commitment of what they have signed.
Thank you very much, Wesley. First and foremost, just like it is said now in the COVID era, everybody has to take responsibility for their actions and inactions. As a borrower, it behoves on you that you go through any document or documents given to you by your bankers. I mean, even if you're an illiterate, you are expected to consult experts, maybe lawyers, maybe your financial advisors, before you put pen on paper. And as it is said by lawyers or in law, that ignorance is not an excuse. If you have put your signature, gun was not put, or it's not put on your head to sign, you sign willingly. And see, one thing that I know over the years, or I've learned over the years, is that you will allow me to say one adage in our Yoruba culture or whatever. It is said that I will just let me interpret it. To eat what do you call it now? In the local, what I call it, peach. I've forgotten the other name they call it now. For you to eat it is very, very easy. But to pay back, to pay the money, is very, very tough. So it's easier to take money than to pay back. And you see people are so enthusiastic when the loan is granted. They don't do it, they don't care again. They just want to sign and draw down. It shouldn't be so. So the first thing is that as a borrower, you have responsibility to go through the terms and conditions of the loan you are being given before you sign. So nobody is forced to take loan. No bank is pushing loan to people forced by fire. It is a decision that you have to take with your eyes open, your ears open, even your heart or your mind must be opened so that you won't put yourself and your family in jeopardy. I mean, GSI now will not only arrest you, we also arrest your wife and your children, the way it is crafted. However, the GSI, just like Professor Abugu also said, is a novel policy that we want to try and see how it works. And let me tell you, there's no policy that's 100% perfect at inception. But over time, by experience and by what you see, from time to time, you want to review what you have put together. We are not saints. CBN and Bankers Committee does not know everything. This is an uncharted water. It's not been tested before. We are just trying to see what we can do to arrest the current situation. There can be imperfection at the initial stage. Over time, you review and look at what can be dropped, look at where it can be strengthened. And like it is said, or the policy is, as it is now, is for only personal or individual accounts. The corporates are no longer there. But I think the CBN and the Bankers Committee are also thinking of how to arrest that area, because the bulk of the loan defaulting or the NPL is actually from the corporates. That said, Professor Waleke mentioned the issue of competency framework. I think in competency framework, the purpose is to train and retrain, certify and professionalize the banking practice, and ensuring that anyone who is practicing banking is properly certified or certificated, if you want to use that language, and properly trained, and they know what and what to do. So what other measures can we take? Let me tell you, 90% of loans go bad the way the day it is approved and the drawdown is made. So if you don't want the loan to go bad from the beginning, and that's where also the issue of competency framework comes to play. Our credit officers, our risk management officers should be properly trained, and they should be carefully selected and recruited. Men of sterling characters, not because they have first class. No. Somebody said your talent is not enough. Talent is not enough. Class of degree is not enough. People that you know is not enough. But people of good characters, of good upbringing, good ethics and professionalism should be recruited in the banking industry, and especially in credit department. People who are painstaking, people who know their onions.
All right, Mr. Olubweme, thank you very much. I just wanted Professor Abugu to answer the second part of my question. That seemed to have escaped his attention. Professor Abugu, I was saying that, fine, this policy, as it were, applies to personal and individual accounts, whereas the corporate borrowers, who are more in number and in terms of quantum as well, in defaulting and repaying back their loans, ordinarily are more of the culprits. I would say in the case of an individual borrower who has converted the monies, whether in his individual account or in several other accounts, into other assets, how do you reach those assets? Through the global standard instruction, and assuming that the collateral that was put forward to use to secure the loan would not be adequate. Does this then make this policy somewhat even more challenging to implement and efficacious?
Well, the GSI as it is now does not address the issue of the use of borrowed funds. And the reason for that, too, for me, is obvious. Once you disburse, the financial institution loses control of the funds. The uses to which the funds are deployed, even when the loan instrument specifies that this is for this particular purpose, the financial institutions do not have the mechanism of monitoring the use of that particular fund. In exceptional cases where it is tied to a particular project, yes, they may inspect from time to time, and then at particular stages in the execution of the project, funds are released. Those are, mechanisms for implementation and use of funds. But it's usually with respect to large projects. So the GSI does not address the use of funds. Now, the legal mechanism for addressing things like that is the security that has been put in place and spelled out in the loan documentation as the fallback position that enables the financial institution to recover its funds. And this is where the issue of prior documentation comes in. This is where the issue of credit assessment comes in. Now, if these are not properly done, then you have a problem. That when there is a default, the financial institution does not readily have a means of, recovering, except by way of, court action.
I was just thinking about that, that
the problem is, and GSI has not addressed that issue. Now, I also see a situation, that for the GSI to be able to trace assets and indeed reach third-party accounts, a mechanism ought to have been put in place. I doubt if it can be done by way of a directive as has been done. But if a statute is promoted by the Bankers Committee and the CBN that enables financial institutions to apply in a summary manner when there is a loan default for a collating of all the accounts that are otherwise connected with that particular individual. And it is
well explained there. The important thing here now is that the GSI does not address so many aspects of borrowing and repayment, which means that if the policy is put into action, there could be litany of court cases, here and there. And if you ask me, from what we have learned from all these professionals, it does appear that more work needs to be done on this GSI, to perfect it and, of course, to be more efficacious and ensure that the banking industry is well to do in terms of carrying out its activities in the economy. Now, we have some tweets coming in here, but there are many. Kingsley, I don't know if we can take one or two of them.
Yeah, just take some of them, yes.
Yes, Priestley, he says, if we are all interested in truly addressing the problems of loan defaults and financial scams involving banks, and if we are up to build a sound banking system, we must have political commitment to let law take its own course.
Now, Adam, that's the Twitter handle. What's going on now is that banks deduct money from customers, usually without any description of the charges.
All right, and of course, Ali Umar said loan defaulters, personal or corporate, can be tracked by using their valid home addresses in order to reverse the fund, even by selling domestic goods.
All right, about Bala Babs, the CBN should also take a look at loan packages from commercial banks. Many Nigerians oftentimes are forced to get these loans to execute one project, business or the other. Oftentimes, these loans come at cutthroat interest rate and other charges that become a burden on the debtors.
All right, if you can take more, let me just take this one. Usman Bankantu.
Yes.
He said the unfortunate side of the loans are that the beneficiaries do not collect the money with good intentions, and in most cases, loans are given out on the basis of who know who. Well, he said no adequate sensitization in the whole process and weak monitoring system. A lot needs to be done by CBN.
All right, that's the number of tweets that we can have at the moment. I would like to thank you for your comments. And indeed, we also would like to appreciate all our four guests who have been with us on the conversation this morning. From our Kaduna Network studios, we were joined by Dr. Yushau Ango, Associate Professor of Business Entrepreneurship and Dean School of Postgraduate Studies at Kaduna State University. I delight having you, Yushau, this morning. And from Lagos, we had two guests via Zoom. We had Mr. Bayo Olugbemi, who is President, Chartered Institute of Bankers of Nigeria. Mr. Bayo Olugbemi, we appreciate you. We also had Professor Joseph Abugu, who is of the Faculty of Law at the University of Lagos with specialization in corporate governance and law of banking and negotiable instruments. With us here in the Abuja studios, Professor of Capital Market and former Commissioner for Finance, Imo State, Professor Uche Waleke, our regular guest on Good Morning Nigeria. Thank you for being around.
Thank you.
All right. So that's it for us today on Good Morning Nigeria. As always, we are appreciative of your tuning in. The program returns same time tomorrow, 7 o'clock in the morning. Take personal responsibility. Stay safe and be well. I'm Kingsley Osadolo.
And I'm Kirian Umayo. Do have a great day.